July 2024 brought about a big change in Georgia's estate planning laws. As of that date, Georgia now allows for the use of a transfer on death deed. What is that? What does it mean? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia, and we'll talk about what that means in today's video. Now, historically, prior to July 2024, if you had a house or some other piece of real estate and you wanted to leave it to somebody at your death, well, you had to put the property into a trust if you wanted to avoid probate. Or you could add them as a joint owner on the deed before your death, but that could bring about some other problems, and that method was generally greatly discouraged because of the risk that you might face. So if you did not create a trust and instead left the house to them in your will, they would get the house, but they'd have to go through the probate process to do that. And that process would take many months and usually involve some level of frustration, as no one really likes going through the probate process, but that was how things worked. Fast forward to 2024, and in the 2024 legislative session, the Georgia General Assembly passed a bill containing provisions for the use of transfer on death, or TOD, deeds here in Georgia. Governor Kemp signed it into law, and the TOD bill provisions, or TOD deed provisions in that bill, that is, became effective July 1, 2024. As I filmed this video in September 2024, I found that many lawyers are simply unaware of these new laws and how it works. It'll take some time for people to become very familiar with this. It's a new planning concept in Georgia, though other states have used it for a while. Here at our firm, we've already filed many TOD deeds for our clients and have begun implementing them into estate planning plans for our clients when it makes sense and when it's a good fit to help them accomplish their goals. Here's how these new deeds work and what it means for you. So to begin with, think of a TOD deed as simply a beneficiary designation for a piece of real estate. So if you've got an IRA, a 401k, for example, you might be familiar that you can list a beneficiary so that when you die, those assets are paid to that beneficiary or those beneficiaries, however you've set up the beneficiaries with the custodian of that IRA or 401k. So a TOD deed kind of works the same way. You're setting up somebody or some people to be a beneficiary to receive that real estate following your death. To set up a TOD deed, that is, a deed is prepared that identifies the beneficiary or the beneficiaries. It lists your name as owner of the property, of course, and it lists the legal description of the property along with certain required language as set forth in these new laws that, among other things, make it clear that the TOD designation, the transfer, is effective upon your death and that it can be revoked before you die. The deed is signed by you, it's witnessed and notarized, and then it's filed and recorded into the land records in the county where it's located with that county's superior court clerk. And when this is done, it means that when you die, the property passes to your beneficiaries, provided that you did not revoke the TOD deed before your death and that you still owned the property when you died. At that point in time, following your death, within 9 months, your beneficiaries will file an affidavit into the land records along with a copy of your death certificate, and then they are going to be deemed the owners of that property. If they miss that 9-month deadline, though, the TOD deed is simply ineffective, and the property is going to need to go through the probate process to pass to either the beneficiaries of your will or the heirs if you die intestate without a will. So that is a hard and fast deadline of 9 months that must be met for that TOD deed to be effective. Now, importantly, understand that if you do use a TOD deed on your property, you can revoke that at any time so long as you have capacity to act for yourself. So this means you can change the beneficiary under the deed or simply revoke it altogether. You can also sell the property or give it away, and that works to essentially revoke the TOD deed as well. If you are revoking the TOD deed without selling the property, you're going to need to file a written revocation into the county land records, have that recorded so that people are aware that you have revoked it and that it's not going to be effective unless that you've gone ahead and given a deed to somebody else that might serve as a revocation. So it's important, if you change your mind, that you're working with your estate planning attorney to make sure that any type of subsequent filing for the TOD deed, if necessary, that it's done properly. Remember, even if you sign a TOD deed to transfer the property at your death, while you're alive, you still own the property and you're still responsible for it. So you're going to need to keep up with and pay for the property taxes and the homeowner's insurance and maintain the property to protect it and to preserve its value, just like you always have, because it's yours. The transfer on death provision is only effective under the TOD deed once you die. And as I said, provided that your beneficiaries file the required affidavit in your death certificate within 9 months. While you're alive, you still fully own and control the property. Now, there's many situations where a TOD deed can be a great tool to use because it can allow you to transfer the property following your death outside of probate. But it's probably not ideal for every situation, including a situation where you want to avoid probate, but you also want to provide somebody the right to live in the property for some period of time and then decide where and how it's going to be distributed. Or maybe the beneficiaries are minors or incapacitated persons and can't really act and manage it themselves. A TOD deed may not be the best option there. Whether a TOD deed is right for your situation is going to depend on a lot of different factors, including your personal financial situation, the age and capacity of your intended beneficiaries for the property, and of course, what your exact wishes are, how you want your assets used and distributed and when following your death. So before we decide what tools might be appropriate, whether a TOD deed is something that would be right for you or not, we're going to want to dive into your situation, understand your goals, your wishes, have a conversation with you about that, and then be able to consider what are the best tools out there that would work to accomplish your goals. If you'd like help with your estate planning needs, including perhaps using TOD deeds here in Georgia as part of your overall estate plan, whether that's right for you, we'd invite you to give us a call. You can reach out to us online at peachstatewills.com, send us a message, an email through that website, or you can just give us a call, pick up the phone and call us at 678-344-5342. We can help you move from procrastinator with respect to your estate planning to the protector of your family with a custom estate plan. Just reach out, give us a call, let us know how we can be of help. Thanks.